Welcome to this explainer. So, go ahead and grab your boarding pass and just picture this. A bright, luxurious ocean liner literally cutting through sparkling blue waves. I mean, it looks like the perfect vacation, right? But beneath that sunny, carefree surface actually lies a fascinating and honestly, a high-stakes world of maritime law. When you step onto a ship, you aren't just stepping into a floating hotel. You are stepping right into a complex legal framework. Today, we're setting sail into the legal waters of maritime liability. We're going to explore the rules that dictate exactly what happens when things don't go according to plan on the open ocean. Now, to understand how our modern rules even came to be, we've got to rewind the clock to a pretty dramatic inciting incident. Picture a beautifully lit, sun-drenched deck back in 1954, aboard a ship named the Himalaya. A passenger, Mrs. Adler, is just enjoying her voyage when suddenly, due to the sheer negligence of the crew, she suffers an injury. Naturally, she wanted to hold someone accountable. But here is the shocking plot twist. When she tried to sue the ship owner, she hit an absolute legal brick wall. A tiny little exclusion clause hidden right there on her ticket completely blocked her from taking action against the owner. It really seemed like the end of the line. But the ingenious legal workaround that happened next changed everything. Now, what's really interesting about this is that Mrs. Adler's legal team did not give up. Since the ticket protected the ship owner, they just bypassed the owner entirely and sued the negligent crew members directly for their actions. And they won. Well, the shipping industry completely panicked at this massive loophole. So, to patch it, they created what is now famous in maritime law as the Himalaya Clause. As you can see, this clause legally extends the exact same benefits and defenses enjoyed by the carrier right down to their servants and crew members. Basically, it was a clever fix born out of a sunny deck mishap.
Let's see how this builds through history. Think of this timeline as a quick cinematic montage through time. We start with that 1954 Adler versus Dickinson case that birthed the Himalaya Clause. But as maritime travel absolutely exploded, it became crystal clear that passengers needed a standardized, almost heroic rulebook to protect their interests across international waters. Enter our protagonist, the 1974 Athens Convention. And the story doesn't end there, because the plot thickens again in 1990 when the financial stakes were dramatically revised.
All right, moving into Section 1, the Athens Convention, where we define the rules of the voyage. So this convention is basically the ultimate script for international passenger journeys. It applies if the ship belongs to a contracting state, if the contract was made in a state party to the convention, or if the port of departure or arrival is in a member state. But what exactly travels with you? On the left, we've got the covered items, like your cabin luggage, your suitcases, and even your vehicle if you're taking it on a ferry. But take a look at the right side. This is where the exclusions live. Things like commercial goods carried under a bill of lading, they aren't covered here. And, maybe more importantly for the animal lovers out there, live animals are entirely excluded. No way, right? So if you're traveling with your beloved pet cat, her safety actually isn't guaranteed under these specific luggage rules. Now, an absolutely crucial point is knowing exactly when you are covered. The period of cover operates a lot like a 3-act structure. Step 1 is embarkation. For your luggage, the clock starts the exact moment the carrier takes charge of it. Step 2 is the voyage itself. And step 3 is disembarkation. If your luggage goes missing and isn't delivered, you've got to lodge a claim within a reasonable time after the ship arrives. But just a quick note on delays here. If your bags are late simply because of a labor dispute at the port, well, that falls entirely outside the purview of the claim. So what does this all mean when things actually go wrong on the high seas? The bright skies darken, the tension rises, and we enter Act 3 of our legal journey. When an injury or damage occurs, who is actually to blame? And more importantly, who has to prove it? Well, under the Athens Convention, liability is strictly based on fault. Generally, the onus is on you, the passenger, to prove that the carrier or their crew messed up. But, and this is a massive legal plot twist, if the injury or damage is the result of a major catastrophe, like a shipwreck, a collision, a stranding, an explosion, fire, or even a defect in the ship itself, the burden of proof dramatically flips. Suddenly, the carrier is presumed guilty. To avoid paying out, the carrier actually has to prove they were utterly without fault, like having to prove a collision with 100% the fault of another vessel. Okay, let's dive into this next part. While the convention protects passengers, it was originally designed to let ship owners limit their financial liability. These limits are calculated in something called special drawing rights, or SDR. Back in 1974, these limits were set shockingly low. Death or personal injury capped out at 46,666 SDR. Cabin luggage, just 833. Vehicles at 3,333, and other luggage at 1,200. These strict limits meant that even if you proved fault, the carrier's financial bleeding was heavily bandaged by the law. But, as we saw on our timeline, 1990 brought an important sequel to our story. The monetary limits were severely outdated, so they were heavily revised upwards to better reflect modern costs. Death or injury limits, luggage caps, and vehicle limits all saw significant bumps. And here is the most empowering part for you as a passenger. Ship owners are absolutely forbidden from legally reducing their liability to any amount lower than what is provided in this convention. These numbers are the hard floor. However, word to the wise, do not leave your diamond necklaces sitting on your cabin dresser. The carrier faces absolutely zero liability for monies or jewelry unless you have explicitly deposited them with the ship's crew for safekeeping. That's a crucial detail to remember. Now, there is one surefire way a carrier completely loses all their right to these financial limitations. If it can be proven that the damage or injury resulted from an act done with the intent to cause damage or done recklessly with the knowledge that damage would probably result, the carrier loses their shield entirely. All right, moving into Section 2, the resolution, where we'll look at time and jurisdiction. Every great movie has a ticking clock, right? Well, maritime law is absolutely no different. 2. That is the magic number. A strict period of 2 years is set within which you, the claimant, must bring about a legal action. This clock usually starts ticking from the exact date of your disembarkation. In the tragic case of a death, it starts from the date the deceased would have disembarked. If an injury later results in death, the 2 years start from the date of death. But there's an absolute hard cap here. The period can never, ever exceed 3 years from the date of disembarkation. So if you are within that 2-year window, where in the world do you actually file this lawsuit? The convention gives you a rapid-fire choice of global jurisdictions. You can sue at the defendant's principal place of business, the port of departure or destination, or even your own personal residence or where the contract was made, provided the defendant actually has a place of business in that specific state. Or, if you can believe it, you can just sue at any place mutually acceptable to both parties. Bringing our narrative full circle back to Mrs. Adler and her 1954 ticket loophole, the rules today are vastly different. Ship owners can no longer hide behind obscure, unread text. Today, owners have to take reasonable steps to bring these contractual terms to your attention, and importantly, this must be done before the contract is even concluded. The carrier is literally legally required to give you notice of the specific provisions of the Athens Convention prior to departure, and wherever practicable, it must be printed directly on your ticket. So, the next time you find yourself bathed in that golden hour sunlight walking up the gangway to a beautiful ship, remember the journey of maritime law. From the Himalaya Clause to the strict protections of the Athens Convention, an entire legal world is operating right beneath the deck to outline your rights, your luggage limits, and the carrier's responsibilities. It all begs the final question: will you actually read the fine print before your next maritime adventure? Thanks for joining me on this explainer, and stay curious.